Hello, welcome to Multnomah Group's 2022 regulatory update. This is something that we do on an annual basis, typically release it in October. This has certainly been an interesting year with a lot of activity. We'll sort of go through some of the highlights. But first, my name is Greg Johnson. I'm a senior consultant here at Multnomah Group, and I am the director of our ERISA Technical Services Committee. I am joined today by second-year law student and retirement plan analyst Candace Finn. Candace is currently in her second year of law school at Lewis and Clark. So thanks for joining me today, Candace. I think we'll have some good insights from a law student. So before we jump into things, we typically cover four areas: the legislative update, look at what's happening with the IRS and the DOL, and then close with sort of what we're seeing as far as fee litigation. I think because this is an election year, things have been moving a little slowly in the first three as far as any legislation, IRS, Department of Labor. However, there are some developments that we think will happen here probably in the next month or so. Some things that'll probably be taking place, impacting retirement plans, most likely after the election is completed this year. So I do think the midterm elections had a little bit of an impact on some of the activity that we saw relative to legislation. For some of you that might not be familiar with Multnomah Group, I wanted to just share a quick slide and do some of the highlights here. We are the investment advisor and retirement plan advisor for over 225 plans, over $30 billion in assets. We actually have expanded through a merger and now have 9 consultants at Multnomah Group. And one thing that I think is unique is the committee governance that we have down there at the bottom. I mentioned I'm the head of the Technical Services Committee. We also have a Vendor Services Committee and Investment Committee that help ensure that the consultants are all sending out a consistent message on behalf of Multnomah Group. So that's a little bit about us. The next thing is to dive right into the legislative update. And I think I mentioned we'll let Candace sort of walk through some of the more substantive provisions. We have had, excuse me, we have had bills pass both the House and the Senate. They're being reconciled, hopefully to get one bill that both the House and Senate can agree on at some point. So, I always remind people, remember, none of these things that we're going to talk about here are actually law yet. We think they will be at some point. I don't know how much is going to get passed after the election, but this is one that I think a lot of people think has the potential to get passed. So, Candace, can you just sort of give an update of where we stand with all this and some of the provisions that are probably more likely than not going to end up in what would be the reconciled bill?
Yeah, thanks, Greg. So I think, starting first off on the list regarding emergency savings provision. So, one of the things that we've seen there would be, a potential add of where plan sponsors could include emergency savings up to 3%, and any excess, of course, that would be contributed could go towards the retirement plan. And so that's kind of one of the items that we're seeing. Another, of course, is the auto enrollment. That would be, you can auto enroll participants up to 3%. It would increase up until you get to 10%. That's one of the other kind of big ones that we're seeing. Next would be, of course, the small sum force outs. Everyone knows right now, I think that's at 5,000. That would increase to 7,000. I think that's force out as well, with given inflation, different things happening. Next would be retirement contributions for student loan repayment. So I think as a student right now, that one's actually really interesting to me as well. Where an employer could, make contributions on the participant's behalf if they're contributing to their student loans. I think we've seen a lot of interest on that one, and I know a lot of organizations are sometimes looking for an options there when they're bringing on participants that maybe have higher education and large student loans. The next would be catch-up contributions required to be after tax, as well for employer contributions could also do after tax. In my tax class, my tax professor loves to call that Rothifying. He says the IRS really loves to do that. They love to get paid now. And then, of course, last but not least, increase RMD age from 72 to 75. So those are kind of, I think, the bigger ones that we're definitely watching that would have, maybe potentially some impact to plan sponsors. I think, Greg, what do you think would probably have the most impact to plan sponsors?
Well, I think some of these are really interesting. The emergency savings sort of came up probably in the last 12 to 18 months. I think I expressed quite a bit of concern during the pandemic when the government essentially opened up the entire retirement system. Anyone could take money out for virtually any reason in pretty significant amounts. I was very concerned about the use of retirement savings for things other than retirement savings. Now, what happened as a result of the pandemic is really the withdrawals were not oh, sorry, a question. Yes, required minimum distributions is what we're talking about with RMD. But as far as the emergency savings, the ability, there is a need to have some access to emergency savings. And I think we know that people have not generally done a very good job setting aside some money for emergency savings. So I'm not opposed to the idea of having some degree of access to the retirement plan assets. Depending on how this particular provision ends up playing out, I think it's going to be pretty reasonable. The original bill that I saw proposed a limit of only $1,000 per year. And also, and I don't know if this part will make it through or not, but it had a requirement that the $1,000 be paid back before you can take a second loan in a following year. So, to me, I felt like that had some guardrails on it that makes it a reasonable way to allow people to get themselves out of a bind. Some of the other ones that you mentioned, looking here, I think the retirement contributions for student loan repayment, as Candace mentioned, that's one that's getting, a lot of people are talking about it. I think the devil may be in the details a little bit as far as how that's administered. So I think it's a positive provision because I think it'll help students get those loans paid off. But I think as to how it's administered may be one of the questions. Probably the biggest impact, though, is the catch-up contributions. So any of your age 50 catch-up contributions would be required to be after tax or Roth type savings. Not all retirement plans even offer the opportunity to do Roth savings in them. So if you're a plan that doesn't have the ability to administer after tax contributions, it may be something that you would want to start looking into because your employees who are using that age 50 catch-up would be required to do that after tax. And of course, the last one, increasing the required minimum distribution age. Just as a reminder, 70 and a half, the Secure Act moved it to 72. And I think all provisions that we're seeing now would move that even further out to age 75. I think that's going to be scaled in, so it's not going to go straight to age 75. Candace, do you have any additional thoughts on these?
I do not. I think, what new legislation are you seeing right now, Greg? Anything else coming out?
So, the one thing about this year's regulatory update is things are just moving so fast. So we published this October 1st, it's October 12th. There was actually already some new legislation proposed. It's called the Retirement Savings Modernization Act. And this is actually a proposed bill that actually seeks to amend ERISA to clarify that retirement assets can be invested across all asset classes. And so what it's focusing on is sort of making the point that retirement plan assets could be invested in things like private equity, real estate, commodities, hedge funds, and perhaps most important, digital assets or crypto. We're going to talk a little bit more about crypto when we get to some of the DOL activity. This new legislation it doesn't really change any laws. A lot of these assets are eligible investments for retirement plans, although most retirement plans tend to focus on, you typically see mutual funds or collective investment trusts as the primary investment. This is really focusing on just sort of almost serving as a reminder to plan sponsors that these other asset classes can be eligible retirement. I think the other purpose of it is to the extent that plan sponsors are concerned about liability by moving into some of these other asset classes, it may relieve some of their concern relative to that. I think we have one question here that I might take on now before we move on.
Yeah.
The fourth provision is to allow employees to take money out of their retirement to pay off student loans. I believe the way that's going to work is students will pay again, that's why I say the devil's in the details a little bit. The way I expect it to work is a student is going to pay their student loan directly up to 3% of their pay, or up to whatever the matching is for the employer match. They will have to somehow prove to the employer that they're doing that, and then it would allow the employer to do the matching contributions. So I don't know if I'm explaining this right, but if I normally have a 3% match, rather than me contributing my 3% into the retirement plan, I'll send my 3% to my student loan, and then the employer will still put the 3% in. Candace, keep me honest. Did I explain that right?
Yes, that is exactly what I had said earlier. So that's great. I think you just gave a bit more detail, which is awesome. I think we had one more. We've had something else come up. I think as investment consultants that you really look at things holistically. When we get to arbitration, we stay away from that. We leave that to the lawyers. But one of the bills that we've recently seen passed in the House was actually part of the Mental Health Matters Act, but it was related to banning arbitration clauses for ERISA litigation. We'll see, as Greg had mentioned earlier, all of this is a maybe. We'll see what happens when we get to the end of the year. That's probably one of the ones we'll kind of be watching closely to see what happens. It's more of a focus on the participants' experience there. So they wouldn't be allowed for pre-dispute. It would potentially be allowed for post-dispute, and we'll see what happens as that moves forward.
All right. So again, that's the legislative update. If anything passes, it will almost certainly be after the election, but prior to the end of the year. If that doesn't happen, then I think it'll probably be at least another year before we see any of these things taking place. The IRS was relatively quiet for the last year. We just had a couple items to update here. The first is the deadline for amendments for the CARES Act and Secure Act was extended to 2025. I think what we're seeing, though, and some of you might be receiving amendments if your plan is through your record keeper. I know some record keepers have already sent out the amendments, so you might have received them. It's okay to go ahead and adopt them. But for those that haven't done anything yet, that is extended. The other item is a pilot program that the IRS introduced to sort of seek to improve the plan audit process. And I think this is interesting. There's no guarantees it'll continue or anything like that. It's strictly a pilot. But what they're starting to do is provide plan sponsors a 90-day notice that their plan is being targeted for an audit or for an IRS review. During that 90-day period, the plan sponsor has provided the opportunity to identify and correct any plan errors that they are able to find by themselves. They are required in writing to notify the IRS of what they did, any errors that they fixed, and what the solution was. And then the IRS can decide to continue to move forward with their review or to cancel the review altogether, is what it looks like the way it's going to work. The good news here is, if you get reviewed and there's issues found by the IRS, you typically have to use the more expensive audit cap correction process. This allows plan sponsors who identify errors to hopefully use self-correction or the voluntary correction program to go ahead and correct those errors, which would be much less expensive. I have not seen any output of what the results of this pilot have been so far. But I think the one question when this was first rolled out is 90 days really a realistic time period for someone to conduct a thorough audit of their plan? And it looks like the corrections are supposed to be completed by the time you notify the IRS. And so I think the question there is whether or not that's enough time. Again, one other item, just came out in the last 2 weeks, so it wasn't included in our regulatory update. There's some proposed changes to the required minimum distribution penalties for RMDs that were required to occur in 2021 and 2022. The penalties would return to normal in 2023. There is actually a real good reason that the IRS is putting this out and proposing it. Just as a reminder for everyone, the Secure Act changed the required minimum distribution rules. Again, it went from 70.5 to 72 when you have to start taking distributions. But there was also a pretty substantive change for beneficiaries who inherit someone's IRA or retirement plan. It used to be that you could use the deceased person's retirement age and really extend those distributions. This changed it to require certain non-spouse beneficiaries to deplete the account within 10 years of receipt. So that happened in 2019, that was passed. Of course, right after that, the pandemic came, and part of the relief on that was to stop required minimum distributions for 2020. So nobody had to take them in 2020. I think the concern is that not everyone has updated their RMD process in 2021 and 2022, which is why there's some relief being provided while we implement the new rules. So that actually just came out this week, I think. So that's another new one. Candace, anything else on the IRS?
No, I think covered everything there.
All right. So moving on to the Department of Labor, there weren't any real substantive rules necessarily put in place by the DOL, but a fair amount of chatter, even what I would call political chatter, relative to certain issues that that impact retirement plans. And maybe we'll start out, let Candace tell us a little bit about some of the comments that were issued by the DOL related to cryptocurrency and whether it can be held in retirement plans.
Yeah, thanks, Greg. So I think, as outlined there on the right-hand side of the screen, the 5 risks and challenges that we're really seeing. One, of course, is the SEC really describes crypto as this highly speculative and extreme price volatility. I think we've seen great notions of that over just kind of, if you've been watching or tracking cryptocurrency, it's kind of been all over the place. One of the other challenges that we've seen is for participants to make informed investment decisions. This is a really highly something that you'd really need to be knowledgeable about in order to be investing in. If it's just really, given the newness of the product, compared to more traditional options, it just would make it harder, potentially for a participant to make an informed decision if you were to have cryptocurrency within your plan. Additionally, a lot of stuff is held within a lot of plans are held within a trust or custodial accounts, or at least the investments. So a cryptocurrency is not held in that, it's held in whatever mechanism that crypto is held in. And then additionally, the valuation, of course, valuation models can be really conflicting. I think we've seen stuff all over the place over the last few years. If you've been watching the price of cryptocurrency, all the different coins that they have out there. And then last, of course, at least, is the evolving regulatory framework. So a lot of rules and regulations governing crypto, everything's evolving at a really fast pace because it is so new. I don't think, I think everyone's still trying to get a handle on it, and we're trying to figure out, okay, what's really the best approach to take here. And so it's interesting to have, that guidance released.
Yeah, and the bullets, this was pretty interesting, sort of what happened about the same time that this guidance or these comments. So it wasn't really a rule. It was just general comments that the DOL was making relative to cryptocurrency. And the way the industry responded has been interesting to watch. This all sort of happened over the summer. Within about 7 days of these comments being released, Fidelity announced that they are going to allow cryptocurrency investing in their plans. So yeah, the DOL saying, hey, you better be careful here. This is not, this carries high risk. It might not be appropriate. You need to take a close look at it. And then within a week later, Fidelity comes out and says, not only are we going to ignore this, we're going to begin developing a product that would allow people access to crypto in their retirement plan. Following that, 3 Democratic senators chose to write a letter to the head of Fidelity, Abby Johnson, indicating, it's in the report, what did they say? That this is immensely troubling, was the words that they used in their letter to Abby Johnson, that Fidelity would go down this path. Another interesting aspect of this conversation, there were several investment trade groups that came together, and they actually went to the DOL and said, hey, you need to pull down those comments because you're not really following your traditional rulemaking process here. You're trying to impact policy just by saying, hey, we're going to share some of our thoughts on what we think is appropriate or inappropriate to invest in within your retirement plan. And you're not following the proper procedure. You're not opening this up for questions and answers from the public. You're just making broad statements that could impact people's decisions. So, I don't know where cryptocurrency is going to end up. There's definitely a lot of back and forth. on this topic. I think the one question that we are seeing quite a bit is, if I don't want crypto, do I need to do anything specific to limit it as available in my retirement plan? Now, the reality is where we're at right now, it's pretty tough to get any crypto and invest any of your retirement plan assets in crypto type investments. You can't hold them directly in brokerage accounts. I think there's some ETFs that are being created that are trying to provide some access to crypto, but it's generally pretty difficult to get it until you have a separate product that's available. I think you'll be able to get it at Fidelity, but I'm not aware of other companies having it available. Now, I do know that if it does become more widely available, typically a self-directed brokerage account is where you would probably see someone gaining access to it. And you can usually work with the provider of your self-directed brokerage account to limit certain assets within that account. Anything else on crypto?
No, I think that covers it. I think, that kind of moves us right into ESG.
All right. So we are expecting for ESG, that's environmental, social, and governance investing. This has become a very hot topic. It has become very political and continues to be pretty political, depending on what side you're on, probably impacts your opinion. But it is true that we are seeing, probably the biggest area that I'm seeing of new products being introduced to the market seem to be in this environmental, social, and governance area. Sort of what's happening with ESG is a week before the presidential election, the DOL under then President Trump issued some guidance that certainly would have made it more difficult for retirement plan sponsors to invest in, to use investments that follow sort of ESG principles. Shortly after President Biden took office, the DOL announced that they would not be enforcing that guidance. They did issue some proposed guidance, but we're still waiting for final rules relative to ESG investing. I think there isn't really any question that it will be certainly more favorable than what we saw under the Trump administration DOL. In the proposed rules, there was one sentence in there that some people interpreted to say, not only can you take ESG into consideration, you should take it into consideration. We'll see what the final rules say. We expect them to come out later this year. I'll be honest, I find it very hard to believe that that is what the DOL meant with that one sentence. I think what you're going to see is that plan sponsors can take some degree of consideration to ESG factors. I think there's been a lot of research to show that younger plan participants do have a strong interest in investing their dollars in these type of investments. I do think you'll continue to see, though, that the ESG will sort of sit on a platform as its own separate tier. So you're still going to have other non-ESG investments. The other thing, though, that I think no matter what happens, I think plan sponsors will always need to follow the exact same rules in monitoring your ESG focused investments as you do any other investment. I think I don't think you should give any special consideration or allow poor performance or things like that to occur longer in an ESG focused fund than you would as compared to any other investment that's offered in your plan. The final thing on ESG is, outside of retirement planning, we have seen, I think it was 17 Republican governors demanding that their pensions not take any ESG factors into consideration in their investment decisions. So that doesn't really impact retirement plans, but I think it just shows, the political focus that we're currently seeing on considering ESG in investment decisions. The final thing that we had from the Department of Labor actually already took place. For many of you who received your second quarter statements, you likely saw a lifetime income illustration somewhere on that statement. This was part of the Secure Act. It was finally put into place. The illustrations that the DOL requires aren't perfect. They do require sort of a point in time. The way the calculation works is It takes your balance as of that date and assumes you were 65 years old and tells you what a lifetime income stream. So there aren't any real projections for future contributions, future earnings, things like that. So, I tend to think that if participants have questions about, hey, what is this? Or it doesn't seem like enough, or I'm way behind. I would generally encourage them to seek perhaps other tools available through record keepers that maybe do provide the opportunity to do some of those projections to get a more realistic view or more realistic picture of where you are in your progress towards retirement. At the same time, though, I am very supportive of the Department of Labor's efforts to sort of shine more of a light on, hey, let's have a realistic understanding of how well you're saving. I think anything that helps individual participants gain a better understanding of where they stand, I think is helpful. I think most participants just see what appears to them to be probably a pretty big pot of money sitting in their defined contribution plan. They may think it's enough, and I think oftentimes what we see is it's probably not going to be enough. Candace, anything else on the Department of Labor?
No, I think that covers it. As you said, we're all kind of waiting for the end of the year to see what's going to happen.
Yeah, for sure. Yeah, that's why this was interesting to write this year, because there's still a lot of unknowns. One thing that is known, though, is the volume of excessive fee lawsuits continues to be very high. We'll talk a little bit more about that on the next page. But one of the biggest things that happened earlier this year is the Supreme Court actually weighed in on on the case against Northwestern University for excessive fees. The Northwestern plan offered, I believe, over 200 different investment options. So, they hadn't really gone through what I like to term plan modernization. When I talk about plan modernization, I'm talking about sort of shrinking down the pool of available investments, having a little closer monitoring. So the plan as it stood was very broad as far as the investments available. And the circuit court looked at those investments and said, well, there's some probably costly, poor performing funds in here out of the 200. But generally speaking, when you look at the entire collective pool of investments, there's plenty of very good investments. And what the circuit court's basis was, well, these are defined contribution plans. Northwestern's not telling people how to invest. They have some responsibility to go into these 200 funds, do their own research, and figure out what the best funds are for them. So, the decision was that generally speaking, people should be able to find whatever they want to invest within these 200 options. And that was their decision, decided in favor of Northwestern University. The Supreme Court disagreed, and I think this one sentence here is probably the most telling. If the fiduciaries fail to remove an imprudent investment from the plan in a reasonable time, they breach their fiduciary duty. So basically what the Supreme Court is saying is you can't look at everything collectively. You need to look at each individual investment option. So it was sent back down to the circuit court for further review. And we don't have a decision in that. I think what the lower court is going to have to do is take a close look at what the process is that Northwestern University used to have these 200 funds available to participants and make a decision whether the process applied to each individual investment rather than looking at them collectively. There was a similar ruling that revived the excessive fee claims against New York University. Now, New York University is one of the only cases that went to trial. It was found in favor of New York University. Very similar decision here. I think at the time the lawsuit was brought, New York University had over 100 investment options. The decision there, the lower court had said, well, the plaintiffs are saying we need low-cost index funds available. And of these 100 funds, there are some in here. They're here. You just have to go get them. So again, the thought process is pretty much exactly the same as what the Supreme Court said, which is you can't just look at everything collectively. You have to look at each individual investment. And so, I think, I'll have Candace sort of comment on how this has impacted other excessive fee lawsuits. But one thing that I expect to see happening, and the truth is a lot of these plans that offer 100, 200 investments have already gone through sort of a plan modernization. They're being sued for things that happened, 5 to 7 years ago. But I do think even the best committees that are out there, if they're offering 70 or 80 funds, and even if they're doing a really good job monitoring them, I think any committee is probably going to have to take a close look at the investments that they're monitoring and putting into the plan, and sort of make a decision. Is that the work associated with making sure that all 70 of these funds are appropriate and proper investments? Should we continue doing that, or should we maybe sort of shrink the investment lineup a little bit? So that happened earlier this year, and Candace, thinking of your civil procedure class, it began to impact some other cases. There were definitely some cases that were sort of waiting. So can you tell us a little bit about sort of motion to dismiss, what it is, and what we've been seeing with some of these other fee cases?
Yeah, so I think, one of the first things is, of course, we see a lot of complaints through, which is a filing by the plaintiff of all of the allegations against usually the breach of fiduciary duty or any other complaints that are involved with the case. Then usually the defendant will file a motion to dismiss. That's where I think a lot of defendants, if you're a plan sponsor, are hoping to get the case dismissed. As was originally done with the Northwestern case with the Seventh Circuit. But with regards to that, though, with the Supreme Court case, we're starting to see a lot of motion to dismiss is being denied, which means that defendants are having to go to court. So I think, this diagram here is a great example of that. Within the first 4 months of 2022, only 3 of the 25 cases filed were dismissed. I think that's a direct product of the Supreme Court case ruling and how things are being evaluated with judges thinking, okay, the bar for defendants to get a motion to dismiss has become more difficult. So of course that increases cost for, if you end up in discovery, that's usually one of the largest costs that you'll see if you end up having to go to trial, where we're starting to see a lot more settlements down the way. People don't even want to try and get to trial just because of the cost of that. Anything extra, Greg? Did I miss anything?
No, I think you're spot on. I mean, I think it makes it easier for plaintiffs to continue moving forward with their lawsuits. And once the defendant is denied their motion to dismiss, I think what we're going to see is a lot of them are going to have to take a real close look, work with their legal counsel, probably work with their insurer, and put a pencil to some paper and really think about, are we going to continue fighting this? Are we going to move into discovery? Are we going to try and take this thing to trial? Or is it best to just get some sort of settlement agreement, get the plaintiff's attorneys paid off, essentially, and get on with our life? Because we're definitely seeing an increase in some of the settlements. So as I mentioned earlier, the volume still remains very high. We see these are cookie cutter lawsuits. Some of them, I think I saw 4 or 5 of them that were all 40 pages, exactly 40 pages long. The only thing different was the names on them and some of the investments that are in there. So, as far as the allegations, they're pretty standard. And Candace, can you just give us a reminder of sort of what we typically see in the most common excessive fee plaintiffs' claims?
Yeah. So in preparation for this regulatory update, I think I read through a lot of complaints, which was very interesting. But there was definitely very much an ongoing theme, and it was really interesting to see how some of them were not just cookie cutter, but almost seemed copy and paste, similar language. I think the first biggest one that we're really seeing is failure to negotiate record keeping fees. People say that their fees are too high. That's usually one of the main ones we see, and I have seen it, I think, in almost every single complaint that I have read related to these types of cases. And then the second biggest one that we've always seen is the lowest share class. So if you are kind of going after individual investments that will be named within the complaint, saying that they weren't within the lowest share class, that they weren't within the lowest fees available for those investments. So that's one of the things that I think we're seeing really across the board, whether, there's some extras kind of thrown in. Those are really the bread and butter that we're always seeing. And I think it's really interesting after reading through a lot of these, we've seen, it's really easy to find these in 5,500 filings. So that's where we've seen even that mentioned, that's been targeted by the plaintiff's attorneys of how they've received this information, of how they're deciding to go after these complaints. So that's been really interesting to read through and kind of see behind, okay, like how are they getting this information? And then how are they assessing this information? So seeing that within the complaints and then these two just kind of being, the bread and butter of those complaints, it's been really interesting to read through. So I'd say those are definitely our top two. And then we kind of seen some extra sprinkled in that I think Greg's going to go over on the next slide.
Yeah, I mean, ultimately what they're challenging is not, well, it shouldn't be. We'll see a little more on the next slide. We shouldn't be challenging the decision that was made. We should be, what they're challenging is the process that the plan sponsor used to arrive at the decision. That's really what we're looking at. So I think for anyone who's concerned about potentially being sued, I think just making sure that your process is as buttoned up as possible, making sure that you have good quality notes and records of things that are happening and decisions that are made, and all those things serve to your benefit in the event that you do find yourself in a court. I mentioned the motion to dismiss. Oh, one thing on this chart, I should point out the 2022 number, looks pretty low, but I think this chart was completed in March or April of this year.
That's correct. It was completed in March, and given the amount of complaints I've seen and read through the summer and well into this fall, I know that has significantly increased. So hopefully, there'll be some statistic numbers through the end of the year that we'll be able to see where the numbers truly are.
Yeah, it continues to go up. And like I said, a majority of them are pretty similar. I mentioned with the motion to dismiss, once the plaintiffs survive that, I think the defendants do have to take a look at what do we want to do here? Are we really going to fight this? Or are we just going to settle? Every settlement comes with some monetary amounts. So there's always a dollar figure attached to it. That's generally been pretty different in most of the cases. I think anywhere from 3 million to 12 million is some of them that I've seen. But I do think it's worth mentioning the non-monetary items that we see in almost every single settlement. We see mandatory fiduciary training for committee members. I'm seeing more and more committees get some type of acknowledgement from committee members that they understand their role as a fiduciary, and capturing that and saving that in their files. Candace mentioned review and use of the lowest share class across the investment options, hiring a third-party consultant. Typically, we see it require completion of a record keeper RFP within the next 3 years. The two new ones that have probably come up in the last 12 months are restrictions on record keepers' use of participant plan data. And then others, probably more in the 403B world, where you have some legacy insurance contracts, requirements that the plan sponsor notify participants of their ability to transfer out of any legacy investments, any individual insurance contracts that the plan sponsor really doesn't have any control over. The other thing, and I'll let Candace comment what we're seeing as far as sort of the asset size, but not unexpected, right? After you get all the jumbo plans out of the way, a jumbo plan is considered probably something with $1 billion or more in assets. I would say the first few years of excessive fee lawsuits almost exclusively focused on what you would see as jumbo plans. It sort of played into their allegation, right? You're a jumbo plan. You had the best ability to negotiate the lowest possible fees, and you didn't do so. So, the argument was that a jumbo plan has more assets, more power to negotiate. But as plaintiffs' attorneys continue to be very interested in filing these lawsuits, you do have to eventually start moving downstream, and we are seeing some of that. And Candace, can you just give an update on sort of what you've seen?
Yeah, so I think, as Greg mentioned, we really saw this in the over $1 billion. If your plan was over $1 billion, that was really where we were seeing a lot of litigation in that space. We started to see complaints filed and even under 500 million. I think the smallest I've seen so far was a $70 million plan with about approximately 2,700 participants. So it was really shocking to see it, litigation having moved that far downstream. So, really into more of a smaller plan size, where you're wondering, what's going on there. But it's been interesting to see how, I think, as Greg said, a lot of the bigger, larger plans have settled. They've either gone through this action where, I think plaintiffs' attorneys are starting to target a little bit more downstream. And as we see this get even smaller, I think it's been really interesting to assess how plaintiffs' attorneys are going about this in their complaints. So, how do you think the lower courts are reacting to this really large increase in complaints, Greg?
Oh, wait, sorry, I was reading a question in the chat. What'd you just ask me?
Oh, you're good. I didn't realize we had
Okay.
Is there a question in the chat we want to answer first?
There's a question about litigation related to self-directed brokerage fees. I think as a plan sponsor, you should certainly have an understanding of what the fees are being charged in your self-directed brokerage account. Really, it's considered somewhat of from a fiduciary standpoint, you don't have a duty to monitor what people are investing in the self-directed brokerage account. It's generally there, really, I talked about sort of shrinking down the available universe of investment options within your retirement plan. A lot of times as plan sponsors do that, they will open up a self-directed brokerage window for that small number of participants that say, hey, I don't like what you've offered me here. I want to go over a self-directed brokerage window. And we typically see under 1%. I think at a minimum of a year, on an annual basis, I would review the fees that are in there. But you don't need to review the specific assets that people are investing in your self-directed brokerage account. A couple additional items that we're seeing. Just recently, with two months ago, I think it's actually 11 lawsuits were brought that target BlackRock's LifePath index funds. These lawsuits are concerning. What we're seeing here is plaintiffs really challenging. They're saying that the plan sponsor just sort of blindly picked the lowest cost investment option and began using it as their qualified default investment alternative. So these are life cycle funds that track the index. They were very low cost, but the allegation is that there were other investments, whether active or passive life cycle funds, that performed better, and the plan sponsors did not take into consideration potential returns. They only looked at costs, and these are just allegations at this point, and none of these have been tried. But I do get concerned. Early on in the excessive fee lawsuits, there was a typical allegation that said you should have been using indexed investing instead of active investing. In my opinion, that's sort of a ridiculous claim, because the investment community isn't even in complete agreement that index investing is superior to active management, or that active management is superior to index. So it's hard for me to imagine a court of law trying to opine on which is preferred and almost make a decision that one is required and is actually better, and that everyone should be using index, not active, or everyone should use active, not index. I think that's a very difficult allegation to prove. I don't see much difference in this. Generally the courts have said, I mentioned earlier, it's not necessarily what you decided, it's how you arrived at that decision. And to now say, we're going to look at your decision, and then further down the line, 3 and 5 year returns, we're going to pull them out, and we're going to get a whole bunch of other investments and see how you did. A challenge to what the outcome of the decision that they made 5 years ago truly is concerning. The unique thing here is that particular index funds in question are what are considered, there's to and through life cycle funds, and a to life cycle fund generally hits its final equity fixed income allocation at age 65. A through index fund reaches that final resting point somewhere later. I think Vanguard's land at 92 or 72. TIAs end at 90. They continue to change that equity fixed income allocation over time. these are very different investment strategies. And the idea that you're going to compare a to investment strategy to a through investment strategy is sort of ill-conceived. It's just not really comparing apples to apples. So I don't think, I mean, we'll see what happens with these. I just don't see how they survive, because I don't see a world where you can challenge the outcome of the decision in this manner. The response to these lawsuits has been largely negative. You know, I think the industry has responded saying, well, if these are allowed to go forward, then no one's safe. Every plan sponsor is going to be subject to potentially being sued. So, you know, we'll definitely be keeping a close eye on this particular set of lawsuits. The other thing that we're seeing is suits focusing on additional products and services, you know, not just focusing on pure investment costs, not just focusing on what's your baseline record keeping cost. And we have one case here. The plan has managed account services where individual participants pay for the opportunity to have sort of an enhanced look at their financial situation and make actual recommendations on how they invest. I think in this case, there was an allegation that the plan was subjected to about $1 million in additional fees that participants paid through the managed account, and they're alleging that that was unreasonable. Anything else, Candace? Did I miss anything on the BlackRock stuff? I covered it.
No, I don't think so. I think you covered it there, you know, and kind of one of the main things, as you said, you know, if they're really going to be going after investment performance and different things, and not looking at how they got to the decision, it might turn into a kind of a free-for-all. Greg, how do you think this is going to impact, you know, how do you think the lower courts are reacting to like this massive increase in litigation that we're seeing?
Well, I don't, that's a good question. Yeah, I think there's some legitimate concern about the volume of these, and you know, these are maybe arguably frivolous lawsuits to some degree. And I think you are seeing some lower courts, despite what may be some good precedents to allow cases to move forward, they're dismissing them anyway. You know, and I think there's still quite a bit to hash out here on what does a plaintiff truly need to allege to allow a suit to move forward. Because I think even despite having maybe a better idea after the Supreme Court decision, I still think it's unclear, because a lot of these suits are based on very just generalizations that, you know, they don't really have any meat on the bone as to what they're alleging, and some of them are moving forward, which I think is concerning. So, you know, the main thing I would say though about all this litigation, that it is definitely the area that we saw in the last 12 months more activity than any of the legislative or regulatory things. It continues to go on. Again, I would just close this piece by saying, you know, looking at the process and capturing the decision-making process that you use for your retirement plan is probably the best thing you can do to keep yourself safe. You know, if the plaintiff's attorneys come knocking and trying to find a few participants and start learning more about your plan, if they recognize that there's high quality, good monitoring, good process in place, they will hopefully just move on and target another plan. The final note that I had, though, was this practice point. I'm sure a lot of you are seeing this, and this is definitely an outcome of litigation. Definitely seen changes from fiduciary liability insurance providers. It's becoming pretty routine for them as the renewal comes up to send plan sponsors a list of questions. I would say when I first started seeing these, they were coming in very informally. They almost just looked like an email from one of the agents just asking some questions. They're getting a little more formal. The questions are getting a little more detailed. I think insurers are recognizing that there may be the potential to have to settle a lawsuit at some point in the future. And so for their part, they're making sure the plan sponsors are meeting regularly. They're making sure, you know, they're asking questions like, do you have a third-party investment advisor? Do you do fiduciary education periodically? And when was the last time? We're also seeing the cost of some of this insurance increasing as well. So, you know, definitely the impact of this litigation is not just felt on on those plans that are being sued. It is having an impact on the industry. And I think the main place that I see it is through the fiduciary liability insurance. So that covers the regulatory update for this year. We do have the Q&A open. We have a few minutes left if people had a few questions or answers. Again, I think, there's still some things to come that we're monitoring. Most notably would be legislation, which if it passes, again, will probably happen in December. And then the DOL's ESG rules. Those are the two biggest outstanding items that I see. And we're going to continue to monitor, and we'll update, provide updates as we get additional information. Candace, anything to add?
No, I think we covered it all. I think that was great.
I don't see any questions in the chat. So if anyone has questions after we close the line, please feel to reach out to me directly or your Multnomah Group consultant. And I'd like to thank you everyone for participating today.
Thanks, everyone.